Did you know that a sitting president could be immune from criminal prosecution? Sounds outrageous, doesn't it? Let's delve into this. This concept, known as presidential immunity, is steeped in controversy and constitutional debates. It's a shield that may protect the highest office from law enforcement scrutiny, potentially impacting the balance of power in our democracy. Imagine a world where the president is untouchable by the law. A chilling thought, isn't it? But where did this all start? Let's travel back in time to understand this better. Our journey begins in the late 1960s with President Richard Nixon. A time of great political turmoil, the Watergate scandal erupted, pushing the question of presidential immunity to the forefront of national discussion. Nixon, embroiled in a scandal involving a break-in at the Democratic National Committee headquarters, attempted to use executive privilege as a shield against legal proceedings. This led to the landmark Supreme Court case, United States v. Nixon. The court held that neither the doctrine of separation of powers nor the generalized need for confidentiality of high-level communications could sustain an absolute, unqualified presidential privilege of immunity. The Nixon case set a precedent, but it didn't end the debate. In the 1990s, the Clinton v. Jones case further clarified the limits of this immunity. President Bill Clinton, facing a civil lawsuit, was compelled to give a deposition while in office. The Supreme Court held that a sitting president is not immune from civil litigation. Fast forward to the 21st century, and the issue of presidential immunity is once again under the spotlight. Enter the era of Donald Trump, a time when the question of presidential immunity has taken center stage. The Trump administration's legal tussles have thrown this issue back into the public spotlight, sparking widespread debate. During his presidency, Trump faced numerous lawsuits, many of which were related to his financial records. These legal battles brought the issue of presidential immunity to the forefront. Was the president, while in office, immune to such scrutiny? This question became a focal point of legal and public discourse. The Supreme Court, the ultimate arbiter of our nation's laws, was called upon to weigh in. The arguments presented before the highest court in the land were not just about Trump's financial records. They were about the very nature of presidential power and its limits. Were the Founding Fathers correct in their belief that no one, not even the president, is above the law? The implications of the court's decision could be far-reaching. It could set a precedent for how future presidents are treated under the law. It could influence how we, as a nation, understand the balance of power between the branches of our government. As we continue to grapple with the extent of presidential power, the issue of presidential immunity remains a hot topic. Only time will tell where we go from here. So, what have we learned? Presidential immunity isn't just a modern debate, but a historical quandary. Its relevance today, especially in relation to Donald Trump, redefines its contours. Presidential immunity is a complex and controversial topic, one that continues to shape the American political landscape. Stay tuned for more thought-provoking content.